Hi, happy Friday. Welcome to Children of Darkness and Light. I'm Lori Hellis, also known as the Good Lori, and somebody suggested that I should call all of you my good friends. So, hello, good friends. Welcome. It's Friday. Hope you're all doing well. It's the Friday before we all head out of town or gather family for Thanksgiving. So I hope y'all have lots to be thankful for. And we have a bit to talk about today about some developments that have happened in the last week. Early on in the week, the judge issued an order, Judge Boyce issued an order saying that Lori was competent. So we'll have to talk about that. And then the judge just yesterday issued an order saying that he was denying John Pryor's motion to sever. And what that is going to entail is going to be very interesting. So let's talk. Let's start with Lori's competency. My understanding is from now, mind you, all these documents are sealed. So we're almost like reading the tea leaves, and we're looking at the what's been filed and what the captions are on the documents and trying to sort of ascertain what's going on. My reading of the documents that have been filed so far is that the prosecution objected to having Dr. Wellner, who was the forensic psychiatrist who evaluated Brian David Mitchell, who was one of Elizabeth Smart's kidnappers. The prosecution objected to having Dr. Wellner evaluate Lori, claiming that there was some kind of conflict. But nonetheless, an evaluation was done, although we're not sure whether Dr. Wellner did the evaluation or not. And based on that evaluation, she was found to be competent. I think I said earlier that if she were to be found incompetent, I thought that restoration services would take a short amount of time. And I think it's possible at this point that her mental health sort of waxes and wanes depending upon what's happening in the case. We all speculated that one of the reasons why she was perhaps feeling a little mentally fragile could be because of John Pryor's motion to sever, which very clearly indicated that his intention is to present a defense that Chad was an innocent bystander, he was duped by a beautiful woman, and that he was set up by Lori and her brother, Alex Cox. So we know that that is going on, and that was going to be some of his argument. And we also know that probably could have contributed to Lori's spiraling a bit and her attorneys expressing concern about her competence. So I think we're going to see this as the case goes on, her ability to track and her ability to cope with the emotional baggage of the trial is going to wax and wane. We're going to see her have easier and harder times. If, as I believe, Lori is still in that mental state where she sincerely believes that she and Chad are God's chosen, that they are God and goddess that are going to lead the 144,000, that they are exalted beings, and that this trial that they're going through is just that. It is a spiritual trial, and they will weather it, and they will be victorious in the end. If in fact that's the case, having her husband, who she is completely all in on, suddenly say, no, I think I was deceived, then I think you can see why she would be a little bit off kilter. So I think we're going to see this sort of transitory questions about competence go back and forth. I think the more concerning decision is the judge's decision not to sever the cases. I think that's going to be very problematic. Some folks asked me some questions about that, and I did talk a little bit about it in my newsletter yesterday, but let's talk about it now. I think that there is a real danger that they're going to get deeply into this trial and discover that there is no way Chad presents his theory of the case and his defense without causing problems for the prosecution or for the prosecution of Lori. So I think we're looking at a situation where we've got a high likelihood that one or the other of them is going to be prejudiced. If that happens, we are looking at almost an automatic appeal. It seems to me at this point that the judge has really painted himself into a corner. I say that because he has decided that the cases are not going to be severed. He has already granted a motion to postpone Chad's trial to give his attorney more time, because his attorney said, I'm not ready, and if you make me go to trial now, it'll be ineffective assistance of counsel. So he didn't want to set himself up for that appeal, but I think he's painted himself into a corner because the judge has said, okay, Chad, you can have extra time, and hinted that the fall might be an appropriate time to be scheduling the trial. And yet we have Lori, who did not and has not waived her right to a speedy trial. The only reason her portion of the trial was vacated, the January trial was vacated, is because she was not competent. So that was vacated and her case was stayed. Now that the judge has determined that she's still competent, she is entitled to have her speedy trial, and she has not waived that. So the fact that the judge is looking into the fall as a potential date to set a trial for Chad, now he said the trials are going to happen together. What does that mean for Lori's speedy trial rights? Technically, he already violated her speedy trial rights because she, according to the timelines, should have gone to trial in October of this year. So the 6 months from the time of her arraignment on the indictment was October of this year. So the judge decided that he was going to continue the trial, set a trial date in January, and that there was good cause to exceed her speedy trial rights. Now, I think the judge probably was just getting away with, it's only 3 months, and there's not that much at stake, and she was incompetent for a long time, and her lawyers have had quite a while to work on this. And I mean, all of the rationale that went into him deciding that. But now we're talking about a continuance that's literally going to put her a year out from her speedy trial rights. So if in fact the judge sets a trial in October of next year, that is a year from the time that she should have had her trial. And she's in custody, and that speedy trial clock runs. And I think the judge has boxed himself into a corner by not allowing the cases to be severed. The simplest thing would have been to allow the cases to be severed, to schedule Lori whenever she wants her trial, and as soon as possible, if she's not going to waive her speedy trial rights, and to schedule Chad in the fall. But that's not what he decided. And so keeping these defendants together, I think, is going to cause some huge appellate issues. Some people also asked me about whether or not I thought the two-jury option could work. Managing a jury trial is like a very highly choreographed dance. And there is a problem if you have a judge that is maybe not up to managing that kind of choreography. You add in a second jury, and that is, it will be very difficult to juggle that. So often what happens in a trial is the prosecution says, we're going to offer this evidence. And the defense says, we object. And we object for XYZ reason. And the judge says, we're going to hear argument outside the presence of the jury. Before we talk about the substance of this evidence, I want to hear arguments outside the hearing, outside of the consideration of the jury. So the jury troops back into the jury room behind the judge's chambers, and the judge and the two lawyers thrash it out, and the judge makes a decision about what sort of evidence there is going to be admitted during the trial. The judge could say, I'm not going to allow that evidence. I'm not going to allow the jury to consider that evidence. Or the judge could say, I'm going to allow the jury to consider that evidence either with some stipulations or narrowing the amount of information, or the judge just may say it all comes in. Then the jury comes back in, and based on the judge's ruling, then the jury, the lawyers will present the evidence, and the judge has determined what the jury will hear. At the end of the trial, then, the judge will give the jurors instructions. And they are usually very specific instructions. They're often provided to the jury, either recorded or in writing. They're read verbatim to the jury. And these are the instructions that the jury uses while they're deliberating. And they're instructions like, if you find that somebody has lied on the stand, you can call into question all of their other testimony. If you are given an instruction to disregard a piece of evidence, you are to disregard it and to not factor it into your deliberation. But there's the problem. The problem is it's very difficult to unring that bell. And it's even more difficult when you have two juries and you're trying to make sure that prejudicial information that could impact their decision as to Chad, for Chad's jury, isn't coming in for Lori's jury. And it is literally somebody juggling and keeping 5 or 6 juggling balls in the air. And so I have some real concerns about whether or not Judge Boyce is up to that kind of courtroom administration, because it takes somebody who is right on top of things, that is making decisions and issuing rulings right in the moment. And that has not been Judge Boyce. Judge Boyce has taken just about every decision under advisement. He very rarely rules from the bench on the day of a hearing. And when he does, they are minor, very procedural kinds of rulings and not anything that has any substance. So I'm concerned about that. I have a lot of questions about whether or not Judge Boyce could handle a 2-jury trial. I have a lot of questions about whether or not presenting all of these facts to a single jury is actually going to be constitutional in this particular circumstance, because John Pryor has already telegraphed to the court our narrative and our theory of the case and our evidence, how we are going to interpret the evidence before us, is vastly different. In fact, he said diametrically opposite from what Lori will present. So I think there's a danger in that. And I'm very concerned about the fact that there are, at this point, many, many issues. We haven't even gotten to trial yet, and already we have some substantive, weighty issues that are going to be appealed. You cannot violate somebody's speedy trial rights for a year and not end up on appeal. That's very troubling, because the remedies for if you violated someone's constitutional right to a speedy trial, the remedy is dismissal of the charges. Now, that doesn't mean that the prosecutor couldn't refile the charges, but that's taking a big risk. That's taking a really big risk, not something I would want to take a risk with. So I have some real concerns about the recent rulings. Let's see, what else? Amy in Boston. Hi, Amy. Do I think that this is going to become an ongoing issue in and out of competency, or this is it? I think that Lori's level of competency is going to wax and wane. I think that it is conceivable that we could get much closer to the trial and she could have a serious period of decompensation, and we could be back to her being incompetent and hospitalized. So, I don't think it's ever a certainty when you have somebody who has this kind of fragile mental health situation. I don't think it's ever a certainty that that you're going to keep that person competent for over a long period of time and get them to trial without any hiccups. So I think it's possible that we could be seeing in and out of competency. I think it's possible that we could just see her sort of go up and down. Oh, good question. How many times can John Pryor file a motion to sever? Does he need a different reason each time? Well, what the law says is that he can file that motion anytime there is a change in circumstances. At this point, I would say that probably means some new evidence, or means that there would be some new basis for a motion to sever. You can't go back and argue the same argument twice because the judge has already decided it. So you do have to have a new basis for it. Now, in Pryor's most recent motion to sever, he did re-argue his earlier motion. The reason for that was because he pointed out to the court that the judge and he had both argued the wrong legal standard, the wrong case law, and that there are cases applying to the severance of defendants, and there are cases applying to the severance of counts in an indictment. And so they were applying the counts in an indictment rules to severing defendants. And so John Pryor said, when you apply the wrong standard, you get another bite at the apple. And he's right. So he was able to argue for the circumstances from his first motion as well as the second one. But going forward, he is going to have to develop some new argument or some new reason why the cases should be severed. Now, if there is, once they get to court, a clear indication that one or the other of them is going to be prejudiced, particularly if there is confession information that comes up under Bruton. We've talked about the Bruton rule. It's a federal case, and under Bruton, if one defendant has confessed, that confession comes in against them, but it can't be used against a co-defendant. So how do you unring that bell in front of a jury? How do you say to the jury, you can consider defendant A's confession against A, but you can't consider defendant A's confession against defendant B. So if that were to arise, if we end up having some confession information, or for example, we have one defendant that enters a plea and pleads guilty, then that could be a serious problem and Pryor could go back and say, we need to declare a mistrial and we need to sever the cases. So it's possible. Why do I think Archibald isn't asking for the cases to be severed? Well, I think the reason why is because his theory of the case is vastly different from John Pryor's. He wants Chad to stay in because that lends credence to their theory of the case is going to be this poor mentally ill woman who believed that this guy was a prophet and she just took everything in he said as face value. And we have all these text messages where he's telling her she's a goddess. And, his theory of the case is going to be so different from John Pryor's. He wants Chad in because then Chad becomes the mastermind, the Svengali behind all of it. And they're able to really divert attention from Lori to Chad. So I would see very much that he would want to keep Chad in the story. Well, my husband has decided to get on the telephone in the next room. So if you hear a little background noise, that's what's going on. Lily here says, can she be deemed incompetent due to religious beliefs? This is an absolutely fascinating question. And I think that it's one that it's always worth revisiting. So here's the question. When does religious belief tip over into religious delusion? Now, we've talked about religious delusion before. We talked about it with Dr. John Mathias. And so I think it's important to know that there is a difference between someone who has deeply held religious beliefs and someone who is delusional about their religious beliefs, meaning it is different for a person to say, I believe that there is a God. I believe that Jesus is the Son of God. I believe that Jesus and God work in my life every day, that they're present. I believe that prayer gets answered. these are all concepts that are pretty mainstream Christianity. But where do we draw the line if we're saying, as Lori has said, Jesus was at my wedding? Not God or Jesus's presence was felt at my wedding, but that he physically in a body was there at my wedding. Where do we draw that line between delusion and a fervently held religious belief? I think that's really hard. I think it's going to be a pivotal question in this case. I think that it's going to continue to be, where's the line? I think is going to be a question that's going to come up again and again in this case. Where do you draw that line? When do you say, we've tipped over into religious delusion? No, you're not a goddess. No, you can't see the future. No, you can't control earthquakes. No, you can't kill someone with your powers. You can't call down the light and make Charles wreck his truck. Those really are much more in the line of delusions. But I think that the defense is going to continue to hammer home, this is an emotionally fragile woman who started out with these deeply held religious beliefs, and here comes Chad Daybell, who takes advantage of this very fragile, emotionally fragile woman and tips her over into religious delusion. And I think they're going to go after saying that Chad was the pivot point, that without Chad, Lori doesn't tip over into these religious delusions. So, this is a good question. Carrie. John Pryor has quite literally done nothing to prepare for Chad's defense, despite having more time than anyone. If Pryor is not ready for trial, whose fault is that? Well, it's John Pryor's fault, but maybe not for the reasons that you might think. I've said before, and I will say again, murder cases in general, and specifically death penalty cases, are incredibly expensive. The average death penalty team consists of 2 lawyers, 2 investigators, and a mitigation specialist. 5 people. And those people are working full time. We're not talking about them doing the odd DUI on the side. We're talking about people who are working full time on this case. You have 2 lawyers and an investigator who are combing through the stacks and stacks and hundreds of megabytes of data. And then you have this parallel track going on where you have a mitigation investigator and a mitigation specialist who are working behind the scenes to construct this argument for mitigating the death penalty. As I've said before, mitigation investigators are looking back 3 generations into medical records, education records, work records, criminal histories, financial histories, to try and build a picture of this person. Why, hello, Kirsten Hellis. That's my daughter. I don't always see her in chat, but it's nice to see her here tonight. So mitigation specialists are looking for a way to convince a penalty jury to spare the defendant's life. The average death penalty case costs $4 million to get it to trial. and potentially as much as another 30 million in appellate work. So John Pryor is a sole practitioner. He took this case on. No one really understands the motivation for either one of the private attorneys who took these cases. Nonetheless, John Pryor took this case. I don't have any doubt that he took the case in good faith. But 3 years hence, the only asset that we know of, which was Chad's home, he signed the title of over to John Pryor in lieu of attorney fees. And I think, when I did the math, I thought, being generous, there might be $100,000 worth of equity there. Now, for the average person, $100,000 is a lot of money. But being realistic about the cost of a death penalty defense, $100,000 is a drop in the bucket. I mean, you can spend $100,000 just dealing with the people who are doing the surveys for your motion to change venue. So there's a huge amount of expense, a lot of experts. I mean, you've got to have an expert who's going to review every piece of evidence, whether it's blood evidence or forensics or ballistics or fingerprints. I mean, whatever it is that you've got to have an expert who's going to review all that evidence and check and double check the outcomes of those. Everything's got to be reanalyzed by your own expert. So the cost is huge. The best thing that Pryor could do right now would be to say, my guy is indigent. He no longer has the wherewithal to pay my fees, and it is a disservice to him because I can't hire somebody to help me. It's really a disservice to him for me to continue representing him, much as I would like to. So I think that the fault for John Pryor is not allowing Chad to have a public defender and not allowing the state to provide the wherewithal for him to actually have a full-throated defense. So it's John Pryor's fault, but I don't think it's John Pryor's fault for lack of trying. I think it's John Pryor's fault for not stepping back. And I don't know what his motivation is for that. Hi, Victoria. I have not heard back on my motions. It's been a little crickety out there. One of the reasons why I toyed with the idea of going over for the last hearing on the motion to sever was hoping to kind of just go and show my face. There is a mechanism in the rules for a person a lawyer to follow up on an order from the court that hasn't been acted on, and I will use that mechanism to prod them a little bit. I do understand that there's a lot of stuff that he's going to have to review if he's going to actually redact the documents and release them as he should. What is Boyce afraid of? Just saw that pop up on the chat. I think he's a very inexperienced judge, and he's afraid of making mistakes. And he also he is a big fish in a small pond, and he operates within that community, and that's what he's accustomed to. And he has been thrust into the limelight in a way that he was not at all prepared for. And I don't know that he's been able to internalize and help. He's been able to really think through how to approach the case and how to approach the publicity and how to approach the notoriety. And he appears to be a person who, rather than thinking through solutions, he just cuts to the, we're not going to have any cameras in the courtroom. So I keep hoping and I keep encouraging the family to contact him and to let him know what the impact is to them. I've provided Judge Boyce's professional contact information, his office, his address for his business, for the court, to anybody who's asked for it. I've really asked that the folks who are following us not inundate him with letters, because I think that would dilute the the powerful message that the family needs to tell him about how his decision's impacting them. So I'm hoping that they will continue to express their concerns. Compassionate RN, is there any way to get details on the secret gag order that the attorneys keep referring to? How can they seal a gag order? Well, that is a fascinating question, because I've never, in 27 years of practicing law, seen a secret gag order. I asked Scott Reich, have you ever heard of a secret gag order? He had not heard of one either, and he's been practicing about that long too. So I don't know that there is a mechanism to force them to reveal that gag order, although I think that we all know it's there. And I do think that the judge is going to have to, at some point, respond to my motions and either justify why he has not revealed that gag order exists, or to say, well, yeah, it does exist. It's mystifying to figure out why he would seal a gag order, because, I mean, he's well within his discretion to issue a gag order and to say to the lawyers and the court staff and everyone involved in the case, the prosecution staff, you may not talk about this case. And he's well within his discretion to do that. So why in the world he would then seal his gag order and pretend that it's a secret, I don't know. But no, so far we don't have any rationale for that. Do I think they will try and impeach Melanie Gibb? Absolutely. Hi, Sarah. So let's talk a little bit about impeachment, because what that means is we have a witness who gets on the stand and they say, I was walking down the street when I saw the accident, and I saw the light was green. And they get to trial, and the witness says, I was walking down the street and I saw the accident, and I think the light was green, but I'm not 100% sure. Well, then what's going to happen is the opposing attorney is going to pull out their deposition or their statement to police, and they're going to say, isn't it true that when your memory was better 2 years ago, when you had just seen the accident, isn't it true that you told the police that the light was green? Well, yes, it was, but I'm not 100% sure now. So that kind of impeachment, bringing up facts and saying, okay, but what about this? That's what we talk about when we're talking about impeaching a witness. So I think that there are several areas where the prosecution did a very good job of nailing down Melanie Gibb's testimony during Chad's preliminary hearing. If you recall, she was one of their primary witnesses, and they really did a good job of nailing down her story, because if she if she deviates from that story, then the defense is going to come up and say, well, that's not what you said at the preliminary hearing. The problem for Melanie Gibb is that other new facts arose after she had her preliminary hearing testimony, when her story was kind of pinned down. A couple of things that came up afterwards, probably the most damning, is the recording that Sherry Dowdle did with Melanie Gibb, talking about the fact that Melanie Gibb was well aware of what happens to people who become zombies, or who become inhabited by evil spirits. She knew that because she knew what happened to to Charles. So she was well aware that people who become zombies disappear. So it's going to be difficult, because that information is going to have to come in to impeach her, to say, okay, this is what you said at your preliminary hearing, but in fact, you weren't being honest in the preliminary hearing, because now we have this piece of information from Sherry Dowdle that says you knew darn well that those children were at risk. You knew because you know what happens to zombies, and you were there the last night anyone ever saw JJ, as Lori was telling everybody he'd become a zombie. So that would be the way that impeachment would come for her. What, if any, charges is Melanie facing? Good question. Potentially false information to police. I think that's probably one of the quickest and easiest ones to get to. I don't know whether the police are going to and law enforcement really care about pursuing Melanie Gibb. But I do think, I'm still convinced that she has an immunity agreement, like Zulema, and that she and Melanie Pulowski, and Zulema, all three have immunity agreements, and that the police have found ways to hold stuff over them and say, if you don't, and the prosecution has found a way to say, if you don't comply with your immunity agreement, we will charge you. I think that's true of Zulema. I think it's true of Melanie's. We saw those charges that were brought against her for identity theft, and they sat there for a few days and then they were dismissed. I think that was just a shot across her bow saying, you better cooperate. You'd better comply with your immunity agreement and cooperate, or we'll just file all these charges and you can go to prison with the rest of them. So, and the reason I say I think Melanie Gibb has an agreement is because when she was in Rexburg or Fremont County for the grand jury, which was May of 2021, when she was there for the grand jury, Mark Means served one of his ridiculous discovery subpoenas on her. And when they served that document, the first thing she said is, I don't have to talk to you, call Rob Wood. That to me says, call my protector because I have a deal with him. So I think potentially Melanie could be facing some lying to police, false information sorts of charges, perjury, some of those dishonesty charges. And I think she doesn't want those. So. Cat Link, could Judge Boyce still step down and let a more experienced judge with death penalty experience take over? Absolutely. Absolutely could. At any point in time, he could say, I feel like this case, I mean, he could say, is really cutting into my ability to fulfill my obligations to the people of Fremont County. It's difficult for me to fulfill my obligations and my duties to my constituency, and it's very important to me that I serve that. And for that reason, I'm asking to be relieved of the responsibility. So, talk a little bit about this in my newsletter. It's a very difficult tightrope to walk, to be as a lawyer or as a judge, to be confident enough to zealously represent your clients, to assert your clients' rights, and yet be self-aware enough and humble enough to know when you're in over your head and admit it. It's a very fine line. And oftentimes those lessons come the hard way, and they come with time and experience and wisdom. And I think that we are watching Judge Boyce in real time, trying to get up to speed and trying to acquire that kind of experience in a really compressed way. And I think that's difficult, if not impossible. And I think that it takes a real secure person to be able to stand up and say, you know what? This is not in my wheelhouse. I'm in over my head, and I need to defer to somebody who can do a better job than me on this. And that's hard when your very profession sort of demands of you that you never let them see you sweat, that you charge forward saying, I got this. So I think that's a tough balance. I think that as we grow older, maybe we get wiser and we learn how to navigate that. But I'm not convinced that Judge Boyce is there yet. Kimberly Stovall says, is Melanice out of jeopardy of prosecution on the attempted murder of Brandon? I don't know that. I think it's a really good question. We do know that she was, if not the only, one of the only people who knew his new address, who knew where he was living with the children. And so I don't know that for sure. We don't know whether they have said we're not going to prosecute for that because we don't feel like we have enough evidence, or whether they've said we're not going to prosecute that as long as you keep your deal with us. So I'm not sure we're clear on that. I want to just take a minute because I forgot to mention something at the beginning of our broadcast, and I want to bring it up. I have two of the best moderators on the planet, Michelle and Brenda, and I made a promise to them when we started the channel that any super chats that come in, so any donations that come in from viewers, would be split among my moderators. And so I want to thank everybody who's sent in a little donation or sent us a super chat, because we're trying to answer every question. It doesn't require that you donate anything in order to answer the questions, but I really appreciate it when I see that you're honoring our mods. The other thing I'd ask you to do is, if you're enjoying this video, if you would subscribe, hit the like button. That helps us move up a little bit in the YouTube algorithm. We're a new channel. We're up against some pretty stiff competition, and some other programs that are going on at the same time as ours. So we just really appreciate it if you would let YouTube know that you are enjoying our content. And so just, as Michelle would say, smash that like button. Um, so we don't know at this point whether Melanice is out of jeopardy of prosecution for Brandon or whether they're just holding it over her head. But I think that will become clearer as time goes on. We have 300 people in chat, so thank you so much for everybody who's catching us live. I know that there's a lot of other competing lives out there, and I know that there's a lot of people who who'll catch us tomorrow and over the weekend. Please, please, please leave your comments below. I don't watch the chat while I'm trying to talk because often I can't walk and chew gum at the same time. But I do absolutely go through on Saturday mornings. I read all your comments. I respond to questions in the comments. I read all of the chat. And a lot of times there's some great questions that come up that are fodder for next week. Also, Tuesday night, True Crime Tuesday. We will be doing a show this coming Tuesday. I just put a little poll out, and it appears that people would like for us to move to Wednesdays. So I think the post-Thanksgiving True Crime Wednesday, we'll switch to Wednesday right after Thanksgiving. But for this week, just before Thanksgiving, we will be doing True Crime Tuesday. Have several interesting things I'd like to talk about. For those of you who have been watching the Piketon massacre trial that's going on, there's some really interesting questions coming out of there that I'd like to talk about. And I have a whole list of other things that people have asked me to address or to talk about other cases, which I'm thrilled to be able to do now that we have this little bit of a lull in the Daybell case. So the answer is Tuesday this week, Wednesday, right after Thanksgiving. There will not be a TGIF on the Friday after Thanksgiving because I hope you're all going to be out enjoying Black Fridays and spending time with your families. So thank you, Chippy, for your super sticker. Thanks so much for everyone who's contributing and given our mods a little love. Satine, how do I get close to the screen for that? Thank you for the super chat. And 2 questions. Are Chad and Lori still together as a couple? Can the feds charge them with anything if they walk on state charges? Both really good questions. The answer to the first one is, your guess is as good as mine. My gut feeling is that Chad, with the help of his counsel, has come to understand that having an ongoing relationship with Lori is probably not good for his defense. And I think he has been doing his best to distance himself from that relationship. It's unlikely that they're having any communication other than the fact that they probably are able to exchange letters because they're all censored and read and recorded, and so what little communication they may be having with one another would be very limited and highly monitored. But I think we have to take a cue from Lori appearing in court the last time she was there, wearing a hair tie on her wedding ring finger. If I had to guess, I would say that Lori is still all in, and I would have to guess that Chad has moderated his opinion now that he has been away from the blonde siren for a while. As to federal charges, I think there are a few federal charges that could potentially be brought. There could be some banking charges because she was using Tylee's money and Tylee's bank card. There could be some federal charges because she was receiving Social Security after the children were dead. And there is a law that requires that you report deaths to government so they can stop paying benefits. Obviously, you're not going to call the government and say, I murdered my children, you can stop paying me now. But that is a federal violation. So I think there's potentially some things that could be prosecuted federally. So thinking out loud. Hi, Beth. What do you think would happen if Chad were to file for divorce? Good question. We talked about this a little before. Idaho has an exception to their marital privilege rule, which has to do with requiring or asking a husband or wife to testify against their spouse. The exception to that rule is that you can't claim a marital privilege if the case has something to do with injury or something to do with the children of either one of the spouses. So you couldn't say there's a marital privilege for a case where someone had a stepfather had beaten their stepchild or any of those kinds of situations. And clearly, murdering your new wife's children falls under that category. Now, a lot of people have pointed out that Lori and Chad were not married at the time that Tylee and JJ were murdered, and that's correct. And they weren't married, of course, when Tammy was murdered. But any communication between them after the marriage having to do with this case, they could claim the marital privilege for. We don't know what that evidence is. We don't know whether there is communication. There was a lot of sloppy texts, and I don't think Lori had any idea how iCloud worked. And I mean, there's a lot of stuff. There was a lot of electronic communication, digital communication out there. So we don't know whether or not there's a piece of information out there that John Pryor would very much like to claim marital privilege for and not have come out in court. If that's the case, it would be a mistake for him to file for divorce. The other piece of it is, I think we don't know what impact it would have if Chad were to file for divorce, what impact on Lori's mental health it might have. And if Chad wants his case to move forward and doesn't want to end up having it delayed for another 3 years, he probably doesn't want to do that and risk rocking the boat and having her end up back in the hospital again. So those would be the two reasons I would think that he would not want to do that. If he were to do that, I think if he were to file for divorce, I think those would be two likely possibilities. And like I say, we don't know if there's something in the discovery that John Pryor would like to keep out and claim marital privilege for. Sarah Nicole, since Lori has not waived her speedy trial rights, when is the latest possible date for the trial in order not to violate her rights? The latest possible date for her trial was last October, last month. Originally, she was indicted on the charges. Remember, she was not indicted until she was found to be competent in April. And there's a 6-month time frame. And so according to Idaho law, her trial, unless she waived her speedy rights, her trial had to happen within 6 months of her arraignment. And that did not happen. And instead, the judge said, I'm going to find good cause to bump this out until January. So the judge, I think, was right on the bitter edge of being able to justify an additional 90 days beyond her speedy trial deadline. I can see absolutely no way possible that the judge can say there's good cause to delay her trial by a year because if he sets trial in the fall of 2023, she will be a year beyond the speedy trial deadline. I think that's a huge problem for him. And I just don't see how you get this kind of concrete, we know what the date is and we're going to ignore her speedy trial rights. It's very cut and dried. I don't know how you avoid overturning an appeal, overturning a conviction on it. Trace Holiday. How will Chad explain Tammy's death if he's blaming everything on Alex and Lori? Well, I think that's a good question. I think Chad will say she died of natural causes. She died in her sleep. I don't know. Is that going to fly? And we don't know because we haven't seen the autopsy. We understand from Chad's children, from Emma, that the autopsy said that she died of asphyxiation. And I'm sure that there are some other indications about indications of what may have happened to her, but we don't know because we haven't seen the autopsy. So it's a little hard for me to say, but I mean, Chad has said all along she died of natural causes. I mean, I didn't have anything to do with it. The fact that Alex Cox was sort of waiting a mile away in a parking lot is a little odd, but it's one of the many inconvenient facts that John Pryor's going to have to deal with. So please email me with questions and suggestions. Got the email there. We're coming up on the hour, and I usually like to wrap up right about an hour. I do want to talk just about a couple things that are going to be coming up. As I said, we're going to move the True Crime Tuesday to True Crime Wednesday, starting the Wednesday after Thanksgiving, and I'll get some notices out so none of you won't be caught by surprise. We won't be having TGIF on the Friday after Thanksgiving, but we'll be back here. We will be doing True Crime Tuesday this coming Tuesday, and we'll be back at it after Thanksgiving. I want to wish everyone a happy Thanksgiving. If you're traveling, please be safe. I hope that you're all surrounded by friends and loved ones, and that you have as much to be grateful for as I do. A couple of other announcements. We are going to do a quilt block of the month for a True Crime Quilt Guild starting in January. I put out in my newsletter the pattern. You can download it off of Etsy. I'll be doing a monthly instruction video on how to make that month's blocks. The quilt itself, the pattern calls for you to make more than one of any specific block. The pattern is a sampler, so you get to learn how to make several different blocks, but you can make it as big or as small as you want. I know fabric's expensive. I know times can be kind of tough out there, so I'm not expecting anybody to make a bed-sized quilt if you don't want to, but at least it's fun. We can make the squares together. My office back here looks like a bomb went off on it because I've got quilting boxes everywhere. So watch this space for samples and sample block patterns. And I think it's going to be great fun, just something else to do while we're waiting for trial. Anybody have any suggestions for cases you'd like me to talk about on True Crime Wednesdays? Or any questions that you might have about cases we've talked about, please send me an email and I will answer questions just as quickly as I can. Those of you who email me all the time know that I try and get back to as soon as I can. The holidays slow things down, but I'm sure they slow things down for you too. I just want to say happy Thanksgiving to everybody. If you haven't seen the new newsletter, there's a terrific recipe in there for praline crunch pumpkin pie, which might be timely for your Thanksgiving dinner. And we will see you all on Tuesday. So good night, everybody. Have a great weekend.